We have done a lot of work on school choice at the American Center for Law and Justice, and one of the big barriers to school choice that's been in the states for decades has been this issue of if we have a school choice program that allows parents to decide to send their kids, whether it's a voucher or tax credit, to a private school, can it also go to a private religious school? The Supreme Court has really clarified now for the third time over a series of cases. This one originated out of Maine, and again, this is Carson versus Makin, 6-3 out of the U.S. Supreme Court. The opinion was written by Chief Justice John Roberts, and it says very clearly, if you are going to have programs that allow parents to choose to send, that you use the money to send their children to a private school, you cannot exclude religious schools.
Supreme Court said that violates. What's interesting here is the free exercise clause. It's one a speech case. It wasn't an establishment clause case. It was the right to free exercise of religion. And the court said, as we've explained in other opinions, interest in separating church and state more fiercely than the federal Constitution cannot qualify as compelling in the face of an infringement of free exercise. So this case elevated the free exercise clause of the Constitution. That's good.
If you set up these school choice programs, you cannot exclude religious schools from the schools that parents can choose from.
Right.
If you look at Justice Breyer's dissent, he argues that this particular decision advances religious strife. He is completely wrong. He's got it backwards. It advances the concept of neutrality as opposed to religious strife. And I think at the end of the day, the American people will agree with it.
The free exercise clause does not allow a burden to be placed on the religious participant simply because they are religious.
The left doesn't like school choice. And anything that could be a barrier to school choice programs, they support. This was a barrier, this idea that if we open this up, is it going to be some constitutional fight that we have to take all the way to the U.S. Supreme Court? Because in some areas, the only choice that people are going to have is potentially religious schools, or they might want to choose religious schools. And so we just won't have a school choice program. But the Supreme Court is making it clear and clear. You hopefully don't have to have another constitutional crisis.
Effectively, this penalizes the free exercise of religion. So, in other words, Harry, if you exclude the religious institution simply because it's sectarian, it meets all of the other accreditation requirements. The Northeast Association of Colleges and Schools, yes, checks that box. Has the significant curriculum that they needed, checks that box. But the fact that they were religiously affiliated meant an automatic disqualification. And my view is here, and I know you've written about this, I have too, is that kind of targeted discrimination is exactly what the free exercise clause was designed to prevent.
Religious institutions, religious parents, they are treated the same as other individuals and groups. And I think at the end of the day, that is what neutrality means. But keep in mind that the progressives on the United States Supreme Court, they are not neutral. They oppose any form of religion within the public square. They assume that Christianity, on one hand, is a majority religion, but then they rightly point out that there are 100 different religions in the United States. So in reality, there is no majority religion in the United States, and so neutrality commands that we treat every single person equally within the meaning of the free exercise clause.
This idea that they could argue the state constitution gives more church-state separation, thus you could exclude religious groups. The Supreme Court finally, and by the way, I've been arguing this for 40 years, finally closes that hole and says, no. A state constitution cannot be used. We had this in New York with a number of cases I litigated at the Supreme Court. A state constitution cannot be used to override the free exercise clause, which again sounds basic, the supremacy clause, but it took this opinion for the court to get there.